Hi and welcome to this introduction to FATCA CRS DAC2. This section will give you an introduction to FATCA CRS DAC2, the IGAs, what caused them, why they're important, what is included in this regulatory regime, what isn't, and why. I'll tell you a little bit about myself before I begin. I'm a qualified accountant. I've got a degree in financial services from Nottingham Business School. I've got Prince 2, which is the UK standard for project management, MSP, which is the UK standard for program management. I'm an adjunct professor of Texas A&M Law School for the work that I've done on FATCA, CRS and DAC2. I'm published in this area. I've got 5 chapters in Professor Burns's LexisNexis Guide to FATCA and CRS, where I write about customer outreach, project management in the context of FATCA and CRS, why it's so different, self-certification and those types of things. I've got 5 chapters in there. I also I've also written a foreword for Ross McGill's forthcoming book on US withholding tax. And last but not least, I should tell you that I've started up FATCA programs for Lloyd's, for the investment banking arm of RBS. I've worked on Barclays, FATCA and CRS program, and UBS. I also write technical solutions for companies like Tainer, the artificial intelligence network, and they have a tool which validates self-certifications, for which I wrote the rules. So that's enough about me, and I shall give you now a brief introduction to FATCA, CRS and DAC2. So if we go back to about 2003, that was when the US implemented the Qualified Intermediary regime. It's worth pointing out that the US represents about 22% of world GDP and sees itself very much as the world's economic flagship. Now, under the Qualified Intermediary Agreement, also known as Chapter 3 of the US Tax Code, any foreign, by which I mean non-US, financial institution had to register for as a qualified intermediary or as a non-qualified intermediary if its customers received US source income. Now, many FIs that were in that position didn't actually go ahead and register. Now, back in around the time of 2006, nobody really knew the true extent of tax evasion because, after all, if it's done well, you couldn't possibly know the size of the funds that were being held offshore, or where, or by whom. Now, around 2006, the US Treasury Subcommittee said that they thought that the US Treasury was losing on a yearly basis 100 billion per annum. So that's a Senate subcommittee saying that the IRS is losing about 100 billion per year that the US Treasury could be collecting by tax receipts because of tax evasion. Now, if you look into this 100 billion figure, what you'll find is it's often quoted, and it's been quoted so often that people are referencing each other, but it actually has no foundation. Professor Burns writes extensively about this 100 billion in the first chapter of his book, the LexisNexis Guide to FATCA and CRS. And that particular chapter, by the way, is available. The first chapter, which discloses all of this information, is freely available. You don't have to pay for that particular chapter to get it. But from memory, that particular chapter is over 100 pages long. In any event, there's no science behind the 100 billion US that it was widely rumoured that the US was missing out on in terms of tax receipts directly because of the tax evasion of US citizens. More recently, it's been said that the size of funds held offshore is somewhere between 21 and 32 US trillion. So 21 to 32 US trillion. Now, as to the veracity of that claim, I can't really say, but it's a number I think comes from Gabriel Zuckman and the Tax Justice Network, and they do have references for it. So it's however you look at it, tax evasion and the size of it's probably quite large. But back in 2006, nobody could really say what the true size of it was, although the US Senate subcommittee said it was around 100 billion for the US on a yearly basis that it was losing. So in those days, nobody could really quantify or get anywhere near quantifying the true size of the quote-unquote problem. That is until the event of Bradley Birkenfeld, who at the time was working for UBS, became a whistleblower. And Bradley Birkenfeld disclosed to tax authorities various records from UBS, and that resulted in UBS being fined 780 million US. Later, I think about a year later, Credit Suisse got fined 2.6 billion US for the same thing. Now, it's worth pointing out that these fines have nothing to do with FATCA directly, which is to say that they were levelled without the FATCA legislation being in place, and it wouldn't have mattered whether FATCA was in place or not. There was enough for the US in terms of pre-existing laws that enabled these fines and these deferred prosecution agreements. Coming up on your screen now will be a list of fines that have come up for tax evasion most recently. And there's about 80 Swiss banks that have been fined in the context of facilitating tax evasion for US citizens. A brief story about Bradley Birkenfeld. So he is the whistleblower that disclosed some of the tax evasion, the alleged tax evasion and facilitation for US citizens at UBS. He was imprisoned for 40 months. He was fined 30,000 US, and believe it or not, he was later given, as a reward for whistleblowing, 104 million US, only in America. So Bradley Birkenfeld, as I say, got imprisoned for 40 months. I think most of that was commuted to being house arrest, and then it was waived, and he got the 104 million compensation. So if we talk about Chapter 3 of the US Tax Code for the moment, that's often referred to informally as a qualified intermediary regime, where foreign, by which I mean non-US institutions, were distributing US income to their customers. They had to register as either qualified intermediaries or non-qualified intermediaries, and many of them completely ignored the legislation. Ross McGill writes extensively on this subject. I think it was something like 1/6 of the financial institutions that should have registered for the QI actually did. And so the US knew that this particular regime wasn't being enforced particularly well, and the IRS itself was under-resourced. It didn't have the resources to follow up on an awful lot of this. But the lack of compliance was really quite blatant. I can give you examples, say in APAC, where under the qualified regime in the old days, self-certifications expired every 3 years, the December after which they were signed. And there were some banks in APAC, for example, who were getting customers to fill out self-certification and asking them to sign it but not date it. And then every 3 years, these institutions were photocopying that self-certification and putting a new date in there. Now, this is absolutely not compliant with QI. They may have believed that it was. It's not compliant with the Chapter 3 of the US Tax Code. The extent to which Chapter 3 wasn't complied with is quite overwhelming, and there's no end of evidence for that. And so, because it wasn't being enforced, because by financial institutions, because the IRS didn't have the resources to make sure that it was enforced, Chapter 4 of the US Tax Code, FATCA, was introduced, and that effectively puts the compliance burden onto banks. Now, it's worth just explaining that when we talk about Chapter 4 and FATCA, that there is actually no Financial Account Tax Compliance Act. It was actually passed as Title 5 of the Hire Act. So there isn't actually a FATCA Act on the US statute books. As I say, it's part of Title 5 of the Hire Act. And what was said in those, and with the US regulations, they have to be self-financing. So if they've got costs, there has to be a means of raising revenues to cover those costs. They can never be a net, but there can never be a net burden on the US public with a new regulation. And what happened was, for FATCA, a line was promulgated that FATCA would achieve for the US Treasury 8.7 billion over 10 years in US withholding. So 870 million in each of 10 years on average over the course of 10 years. So 8.7 billion over the course of 10 years. And this was used to finance the rest of the Hire Act. That's how it was passed. Now, it's worth pointing out that the IGAs, and this is going to be somewhat controversial, I'm going to cover it at length in this course, the IGAs themselves almost negate withholding. And this 8.7 billion that Title V of the Hire Act was passed on was ostensibly going to be income to the US Treasury from withholding on non-participating financial institutions and recalcitrant account holders. The IGAs have all but negated that, and I'll explain why later. So the revenue that was supposed to come in from Title V of the Hire Act to finance the rest of the Hire Act never actually came and isn't coming. But having said that, many US taxpayers who were hitherto using offshore devices have now disclosed as much to US tax authorities, and it's widely believed that the US is now getting an extra 10 billion in terms of revenue from those formerly offshore alleged tax evaders. So it isn't to say they've got no income, it's just not from withholding directly. So what was the purpose of the US Treasury version of FATCA originally? Well, it was to make sure that the average member of the public who was banking in the US had the same opportunities as more wealthy customers who were using offshore accounts. And the US wanted to put an end to this two-tier system where the wealthy have one range of tools available to them and the average member of the public doesn't. Also, FATCA was written into the statute books in March 2010, very time proximate to the financial crisis of 2007-2008. There was a move at the time to regulate the banks, Dodd-Frank, and to regulate tax evaders, FATCA. There was, however, one major flaw with the US Treasury version of FATCA. It was other countries that had to apply it, and this was an American law that in no way meant that it was going to become law in other countries. And yes, the US does have withholding, that was the stick at the time, and they do have 22% of world GDP, so they are the world's leading economy with the world's reserve currency. So in fact, withholding was very much used as a stick then. But there was a reticence in other countries to enforce what is, after all, an American law to detect US tax evaders. What the US Treasury did was they negotiated an intergovernmental agreements with lots of other countries. And it's worth pointing out these agreements were negotiated by the US Treasury, not by the Inland Revenue, a totally different arm of government. And so the US Internal Revenue Service may or may not have agreed with the agreements that were made. Nonetheless, they were made. There are three different types of IGA. I'm going to split them into the two main types, which is Model 1 and Model 2. If you are a Model 2 IGA jurisdiction, which includes countries like Japan and at the moment Switzerland, then FFIs sign a FFI agreement with the US IRS, and those IGA jurisdictions also make the relevant modifications to local law so that local financial institutions can comply with the FATCA regulations, so that they can report to those to the US authorities directly. So generally speaking, Model 2 IGA countries report directly to the US via a system called IDES, and the FIs in those jurisdictions sign an FFI agreement with the US to enforce FATCA. Model 1 IGA countries don't report directly, generally speaking, to the IRS, don't use IDES. FFIs in Model 1 countries report to their host country tax authority using a schema and platform, which in most cases is unique to that particular jurisdiction. Many of them are similar, but in each case you're reporting to your own unique host country tax authority in most cases, rather than using the American IDES system. FFIs in Model 1 jurisdictions don't sign an FFI agreement. Instead, their legal obligation is covered always by local law. So this is very important. They don't sign an FFI agreement at all at Model 1 jurisdictions. There are many reasons why this is important, but one of them is that when people talk about FATCA obligations, they're often talking about US Chapter 4 of the US Tax Code. Because in Model 1 jurisdictions no FFI agreement is signed, there is no US Treasury version of FATCA that these local FFIs have to comply with. Instead, they comply with their own local law, and that's often very, very different. In Model 2 jurisdictions, they're signing an FFI agreement, and that ties them. And the FFI agreement's with the US IRS, and that then ties the FFI in an IGA jurisdiction to the provisions of the US Tax Code, which are in 1471-4 of the US Tax Code. So, in Model 1 jurisdiction countries, the US Tax Code Chapter 4 doesn't apply directly. In Model 2 countries, the US Tax Code doesn't apply directly except for 1471-4. Okay, that's very important, because the FFI agreements and the US Treasury version of FATCA for non-IJ countries, they tie in FIs into the responsible officer concept, where an individual has to take responsibility for the compliance of the FI of FATCA, and has to give a attestation to the IRS that they're complying, that they have a compliance program in place, and that they're continuing to comply. They also have to reveal where there has been, via a qualified attestation, where they haven't been able to meet the provisions of FATCA and what they're doing about them. The distinction between an FFI agreement and the responsible officer is a really important one. So in Model 1 IGA laws, there's no concept of a responsible officer. There's no concept of an individual making an attestation to the IRS, or indeed making an attestation to the host country tax authorities. That isn't to say there shouldn't be compliance, so on and so forth, but it's not as prescriptive, it's not specified. Some would argue it's implicit, but it certainly isn't explicit, it certainly isn't in the regulations per se. It may, however, be good practice. So just to reiterate, because it is important, the US version of FATCA, the US Treasury version of FATCA, Chapter 4, has concepts of the responsible officer, attestations, continued compliance, and all of this being evidenced. This isn't the case as a regulatory requirement for Model 1, and isn't the case for Model 2, except for when the FFI agreement writes into, includes the parts of Chapter 4 that are in 1471-4. It's worth pointing out that the US Tax Code Treasury FATCA is Section 1471 to Section 1474 inclusive. So sorry to be so prescriptive and boring about that, but as we'll find out later in the course, this is going to turn out to be very, very important. And that's why I've belaboured the point so much. Now, there was one problem with FATCA, and that was that it had to be implemented by other countries, and other countries wanted concessions in order to implement it. The UK was the first to sign an intergovernmental agreement with the US Treasury, and that was December 2012. And what the IGAs do is they eliminate withholding for FATCA. But I'm going to explain something that's really important before I explain all of this. I'm going to make a heroic statement. So a heroic assumption I'm getting from the discipline of economics here. There's no withholding for FATCA, and I'm going to explain it. I'm going to explain it at length. And by the way, if you want to argue with me about it, feel free to ask me to pause the video, and we'll talk about it, because it's important that it's understood and that it's agreed and that it's explained. But withholding is an important part of Chapter 3. Okay, and all the fines we talked about earlier, they all come from Chapter 3, not from Chapter 4. And so when I'm saying that there's no withholding for FATCA, which I'll explain, I'm not saying there's no withholding for Chapter 3. There's a massive amount of withholding for Chapter 3. It's very complex and it has to be done properly. And the reason we often talk about withholding in the context of FATCA is because when you're looking at withholding, the first question you have to ask is there withholding for Chapter 4? And if there is withholding for Chapter 4, then you don't ask the question, is there withholding for Chapter 3? Because you go to Chapter 4 first, and only if there's no withholding for Chapter 4 do you go and say, well, do I have to withhold for Chapter 3? Under FATCA with the IGAs, there will virtually never be withholding. You still have to ask the question, has there been withholding? And only then say, right, should I be withholding for Chapter 3? So I'm not saying that there's no withholding for the US, there's no withholding for US tax. I'm saying there's massive amounts of withholding for US tax. I'm saying that it's always going to be Chapter 3, except on lunatic fringe examples, never on Chapter 4. There's a phrase in the UK that we often use, and that's never tear down a fence until you find out why it's there. And the reason I'm stating it, to continue the analogy, is that if you move into a house and you take down a fence, you want to find out why the fence was there before you find out that the reason that fence was there and was so high was because of next door's Rottweiler. And so, to explain the analogy, to say things like there's no withholding is for US tax is completely incorrect. There is US withholding for Chapter 3. There's a lot of it, and it is complex, and it is terribly important. So please don't tear down that wall. It continues, but please don't confuse it with FATCA. It's a qualified intermediary / US Chapter 3 issue, and I'm in no way negating the importance of it. You can get fined for non-compliance, big time, reputational damage, big time, and all of these fines we've talked about before, they all come from Chapter 3 and not from Chapter 4, so it is important. What the IGAs did was they negated withholding. Now, they didn't negate withholding for Chapter 3, so the way that the IGAs negate FATCA withholding, so Chapter 4 withholding for the US, is this. They, because you can only withhold for FATCA, bear in mind, for 2 FATCA classifications. I'll explain how you get to those classifications at length, but you can only withhold for FATCA, and this is always true. This is true inside of an IGA, outside of an IGA, Model 1 and Model 2. Okay? You can only withhold under FATCA, notwithstanding withholding for Chapter 3. You can only withhold for FATCA on non-participating financial institutions and recalcitrant account holders. Now, under the IGAs, the only way you can have an FI that's a non-participating financial institution in that particular jurisdiction is if that particular financial institution has gone through a rather lengthy and very prescribed specific process of significant non-compliance that hasn't been resolved. So in the UK, our IGA says that that particular process takes 18 months from having been triggered, and only if after the 18 months from having been triggered that the host company, the HMRC in this case, hasn't been able to resolve it with the FI, the HMRC will then notify the same to the US IRS. Now, the procedure is not always the same in every IGA. Okay, so in the UK, there's an 18-month process once it's been triggered. Japan, a Model 2 IGA jurisdiction, there's a 12-month process once it's been triggered in the moment. But this is an important point. So you've got two FATCA classifications on which it's possible to withhold. They're non-participating financial institution, and I've explained the complexities there. I'm going to come back to it. The other is recalcitrant account holders. The IGAs negate the concept of an NPFFI by introducing this process of significant non-compliance, and they negate withholding on recalcitrant account holders by reporting on them. So there's no reporting on recalcitrant account holders while they are reported on. So to say it a different way, HMRC in the UK do say this, there should be no withholding under FATCA unless there's been an error in the way that the FATCA has been implemented in that FI. So how do financial institutions implement FATCA CRS Status 2? Well, if we start first with the US Treasury version of FATCA, and this is true actually of all the regimes, be it FATCA, DAC2, CRS, and I'll explain what DAC2 is, by the way, for those of you who are familiar with the terms FATCA and CRS but not DAC2. I will come back and I will explain it at length. How do these regimes work? Well, at the simplest level, and this is very important to understand, if you like, this few-step process is really the Rosetta Stone of understanding FATCA, DAC2 and CRS. How do they work? Well, reporting financial institutions identify financial accounts. They then identify the reportable accounts, and they apply due diligence to identify which of those accounts are reportable. And before the advent of the IGAs, it would have been which would be withheld upon in the context of FATCA. Okay, and they then report on the reportable accounts. It's quite simple. Now then, that does sound simple. So the first thing is, are you a reporting financial institution now? One of my clients was contacting me from South Africa, where they're based, and they have pension funds in the Isle of Man. And they wanted to know what their FATCA and CRS obligations were, because they'd been told by a Big Four firm that they had these huge obligations. And an executive from that company contacted me, and I explained to him that after asking him lots of questions, that the companies that he has in the Isle of Man are all pension companies, therefore they're not reporting FFIs and don't have reporting obligations. He didn't believe me at the time, only paid me half of my fee, and about a year ago he did realise that I was right and paid me the lot. I don't know how his conversation with the Big Four firms went, but it's important that first of all you ask yourself, is the entity in question a reporting financial institution? Because if they're not, they don't have the same obligations. Okay. So once we've established that the entity in question is a reporting financial institution, we've then got to look into their financial accounts. And this is important because we don't have to do FATCA due diligence for customers without financial accounts. And also there are only 5 types of financial account recognised by FATCA, DAC2 and CRS. Also, every jurisdiction has exceptions to what are financial accounts. They're excluded accounts, if you like. And so you need to look at first, am I a reporting financial institution? And then you need to look first at, am I a reporting financial institution? And then look at, what are my financial accounts in the context of FATCA, CRS and DAC2. Then you work out, well, of my financial accounts, which of them are reportable. And so in the context of FATCA, that would be specified US persons, recalcitrant account holders, NPFFIs, controlling persons who are US persons. But how you determine whether an account is reportable is by classification. This is a very important point which I'm going to come back to later in this presentation. I think I'm going to test you on a few things, just so that I know you've all paid attention. So, how do you determine whether an account is reportable? Is a question I'm going to ask you later on in this course. But the answer to that is by giving them a Chapter 4 classification, okay, a FATCA classification. And in the context of CRS, you do the same. You determine whether they're reportable by giving them CRS status. Okay. We determine whether an account is reportable, and we determine whether an account can be withheld upon by first giving it a FATCA classification and a CRS classification. There are material differences between the US Treasury version of FATCA and the IGAs. In Model 1 IGA countries, there's no concept of a responsible officer. There is no concept of attestations being made to the IRS directly. There is no concept of attestations being made to host country tax authorities. An exception being in Model 2 countries, where parts of the US tax code, relating to FATCA, specifically 1471-4, can be imposed indirectly because they are introduced as part of an FFI agreement which are signed by Model 2 IGA jurisdictions, and they are also signed by non-IGA FFIs in non-IGA jurisdictions.
And just to recoup on some of the key points, from the introductory first section. That is, number one, the no withholding for FATCA or Chapter 4 of the US tax code. Having said that, I should now tell you about the exceptions to that. Naturally, all of the tax code applies to the US itself, and that includes Chapter 4. So in the US, Chapter 4 absolutely applies. FATCA absolutely applies, and that includes withholding. Okay, so that's the US itself. Then you've got the non-IGA countries. The one additional exception, a subsidiary of a US withholding agent, and that particular subsidiary, because it's a subsidiary of a US withholding agent, it has to withhold. And so let me explain why that is. That is that if you are a branch of a US withholding agent, the fact that you're a branch of a US withholding agent overrides the IGA. So the logic still stands. In IGA countries, the IGA is negated withholding because of the significant non-compliance routes to becoming MPFFI, and because you don't withhold on a recalcitrant account holder, you report them instead. Okay, but where you have a branch of a US withholding agent, the fact that you're a branch of the US withholding agent supersedes the fact that you're in an IGA country, and so you have to apply Chapter 4 and withhold. I hope that's clear and that's understandable. And if it's not, let's stop the recording and let's talk about it. In those IGA countries, the regulation you've got to comply with is the regulation for those local is the regulation in those local jurisdictions, the legal instruments that those local jurisdictions have written. It's not the US tax code unless you're in the US, or if you're talking about Russia, or you're talking about that Belgium subsidiary. Your target for compliance in terms of FATCA is the legal instrument which the local jurisdiction has written to implement the IGA. Okay, so some people, what they do is they go straight to the IGA. Just bear in mind, an IGA is not in itself a legal instrument. It's indicative, but it's not a legal instrument. The legal instrument is the Act of Parliament, or the Act passed by the local jurisdiction. So keep that in mind. If we're talking about a jurisdiction, tax jurisdiction, that's in an IGA country, its target for compliance in terms of FATCA is always going to be the legal instrument in that local jurisdiction which implements the IGA, not the US version of the tax code. They're similar, but they're not the same. It's like if you like comparing American football with rugby. You can see some similarities, but there are major differences. I suppose if you like, withholding is the equivalent of a forward pass. You don't get a forward pass in rugby, but you do get a forward pass in American football. So they're similar, they're not the same. Continuing on with that theme, I'm going to explain the evolution of the US Treasury version of FATCA to the IGAs, to CRS and DAC 2. And it's important to understand this because it helps contextualize how FATCA under an IGA is so much lighter than the US Treasury version of FATCA, and also helps you to understand how similar the common reporting standard is to FATCA IGAs under a Model 1, and why that is, the general trajectory of which the compliance of these regulations are going, and what compliance looks like and what you should be aiming for. Okay, so let's do that. So you've got US Treasury version of FATCA tax code, Chapter 4 of the US tax code. A very, very high bar, includes withholding, so on and so forth. We've covered that at length now. There's only one problem with that, and that was that FATCA itself has to be implemented in countries outside of the US, and to get countries to do that, they're going to want to form an agreement with the US Treasury and to get some concessions for their own local FFIs. That's just the way it works. There are 113 IGAs in place with local tax authorities, HECTAs I'll call them, so host country tax authorities, and the US Treasury. 113, it's been 113 since, it's been that way for at least 6 months. And I should explain that not all IGAs are the same. So as I explained in the previous video, and I believe I said there's 3 types, and I explained 2. So you've got Model 1, you've got Model 2. Model 1 is split into two types. You've got Model 1A, Model 1B. Model 1A has reciprocal reporting, so the US will reciprocate with reporting back to those HCTAs, host country tax authorities, that have a Model 1A. Model 1B, there's no agreement for reciprocity. And Model 2, there are, amongst all of the Model 2 that are signed, I think all but 5 contain an allusion directly to the word, well, they contain the word reciprocity, but it's based first on the US receiving the information that it requires from that Model 2 jurisdiction. So Model 2, sign the FFI agreements, responsible officer responsibilities, attestations directly to the IRS, and most of the time Model 2 use IDs to report to America directly. Model 1, reporting to host country tax authority. The host country tax authority then reports to the IRS. And those Model 1s, for the most part, have their own local portal, and they have variations of that. Most of the schemas for Model 1 jurisdictions are the same, but there are exceptions, and those exceptions are a bit of a pain, in all honesty. So you've got things like in South Africa, they've got their own version of the schema, which is very different from other versions of the schema. In Luxembourg, you can't submit the schema without using a third party. I think it's FundSquare is one of them, and Sophie is another. Neither of those are free. Now, they don't cost an awful lot of money, but it's you've got to get permission from the part of the bank to engage with either Sophie or FundSquare. And you've got to set up legal agreements, and it's a right pain in the proverbial sometimes, just because of the amount of variation there is in reporting. Now then, I digress somewhat there, so apologies for that. Let me explain what I've set out to explain, and that's the evolution of these agreements. So, US version of FATCA couldn't work on its own, had to, because other countries had to actually implement it. To implement it, they wanted agreements with the Treasury that gave them concessions, and those concessions included no withholding, provided that the FI implements FATCA correctly. We've explained what we mean by that at length now. And what happened was the UK was the first to sign an IGA. I think it was in 2012. I think it was in December. And then the EU G5, so the European Union G5, they all signed IGAs with the Treasury based on the Model 1 IGA. I don't think it was called a Model 1 IGA at the time. It was only when the variant, the Model 2 came out, that the Model 1s are referred to as Model 1, and the distinction was made. Now, the important thing is the EU G5, and I think that's the UK, France, Spain, Germany, Italy. They agreed to share automatically this information intra-EU G5, i.e. amongst themselves, okay? And they then took that approach to Europe, and they then took it to the OECD. And the OECD decided to adopt that model, so the Model 1 IGA approach became part of the automatic exchange of financial information, or automatic exchange of information. The automatic exchange of information has two components. That's the MCAA and the CRS itself. So the MCAA is the Multilateral Competent Authority Agreements. That's agreements between host country tax authorities, HCTAs, to share information between themselves. And then you've got the CRS, the Common Reporting Standard, which we, for the most part, know about. Okay, so that's why CRS is so similar to a Model 1 IGA, is because that was the genesis of them. They started that way. Now, in the and there are many advantages to firms of CRS being so similar to Model 1 IGAs, and it's because the regulation itself is so similar and the approach is so similar. And to give you an example of how important it is, Switzerland is in the process of moving from a Model 2 IGA to a Model 1, and the reasons for that is because the Model 1 IGAs are so closely aligned to the CRS. So you've got the US version of FATCA, you've got the IGA so that FATCA can actually happen. Then from that, you've got the AEOI, Automatic Exchange of Financial Information, which has two components. the MCAA, Multilateral Competent Authority Agreement, and the Common Reporting Standard. Now, one more thing to add to that. In the EU, we implement, so the EU member 20, all of the EU members of 28 states, including the UK, and there's no sign of that changing for quite some considerable time, if indeed ever. So all of the EU 28 member states implement not the CRS directly, they implement that regulation through DAC2, which is a regulation very similar to the Common Reporting Standard, but it does things like it brings to an end the EUSD, the European Savings Directive, and so it's similar, but it's not the same. It's important to bear in mind that when the EU 28 are implementing the automatic exchange of information, the regulation they're trying to comply with is DAC2, and that local member states write local instruments to bring into place compliance with DAC2. Now, hopefully for the very last time, I'm going to hark back to the US Treasury version of FATCA for a reason. It's to explain the history and to explain the approach, and hopefully all things being equal, from there on out, when I refer to FATCA, I'll be referring to the IGA version of FATCA. So here I'm harking back to the Genesis, the US Treasury version of FATCA, and I'm doing it for a reason. I'm doing it to explain the process of classification and how it worked. Okay, so under the US Treasury version of FATCA, when you were classifying legal entity customers, there was very much a prescribed approach. You'd start with, okay, let's look at our entire customer base of legal entities. How many of these customer legal entities are specified US persons? Now, how would you know? Well, a specified US person is a person that's reportable for FATCA, and it may meet all sorts of other definitions, but in the context of FATCA, a specified US person is a person that's reportable for FATCA, and that's not all Americans, okay? How you would know is because you would get Americans to fill out a W-9. The W-9 tells the requestor of the form that that customer is an American. And in all cases, for an American, you would get a W-9, okay? And there's a box you tick for exemptions to FATCA reporting with codes, I think it's A through to M, and it includes things like being a US bank, being a 501c corporation, a real estate investment trust, things like that. So a specified US person is an American except for somebody with an exemption, and codes A through to M, and they tick that on a W-9, which you'd always request of an American. Okay, so first question you would ask of your legal entity customers when trying to classify them for the US version of FATCA is the customer a specified US person? If the answer is yes, then they're reportable. They go straight to what's my left side and will be your right side on the screen. So specified US person, reportable. Okay. Then you look to things like, okay, now is the customer an exempt beneficial owner? Exempt beneficial owners are things like US governments and subsidiaries of US governments or other governments. So those kinds of beneficial owner, they're carved out this way. So to my right, to your left. So carved out means no reporting. And because I'm harking back to the US version of FATCA, I'm also saying no withholding. So carved out, no withholding, no reporting. Other examples of carve-outs would include things like, are they international organisation? That would include things like the Red Cross. They'd be carved out straight over to what's my right side and will be your left side. So no withholding, no reporting. Central banks, things like the European Central Bank, carved out. Okay. And so once you've gone through, you've put your specified US persons to this side and you've carved out your exempt beneficial owners to this side, you're then left with a population, and you classify them as either FFIs under FATCA or NFFEs. Okay, and so A foreign financial institution is an institution. Now, they used to use this indicator called prima facie FFI. You can't use that anymore. That was when that's an old part of FATCA. But essentially, when you know that an FFI is an FFI from things like having a GIN, and I'll explain GINs for those of you who don't already know a little bit later. I've given you a GIN, or you've got a W8, say, which is a form of self-certification, or another form of self-certification, or you've got your pre-existing AML KYC already tells you that that's a financial institution, then they're an FFI. Now, I'm speaking in very simple terms here, but bear with me. That in simplistic terms, that's the way it is. And then you've got NFFEs. And your NFFEs are the population you had that you couldn't say were specified US persons, you couldn't say were an exempt beneficial owner over to this side or carved out, and you couldn't classify as a financial institution. Okay, so those then are, under this approach, non-financial foreign entities. And you split non-financial foreign entities into two parts. Now, each of those two parts has various splits on top of that. But the important thing to note at this stage is you split them into two parts, two major categories, and there are subcategories of each of those. The two main categories are that of an active NFFE, which you would carve out. I know there's going to be some contention here, so I'm quite prepared to pause the recording if that's required. And you've got passive NFFEs, and there's more work to do on those. Now, with active NFFEs, you've got many different subcategories. They're things like they're regularly traded on a recognised securities market. Less than 50% of their income is from passive income, a defined term. And your pre-existing KYC AML could also tell you that they were an active NFFE. So, for example, if you're dealing with like Royal Dutch Shell or something like that, it's very likely that you'll have enough information on your pre-existing AML KYC records to know that that is an active NFFE. And so the passive NFFE is a default category. Okay, how you got there was it wasn't a specified US person, it wasn't an exempt beneficial owner, you couldn't classify it as an FFI, so it became an NFFE. You couldn't classify it as an active NFFE, so you're left with passive NFFE. If you like, it's a default status. And you have to do quite a lot of work on these passive NFFEs to establish the controlling persons. We'll deal in more detail on that in just a moment. The important thing here is that for the US Treasury version of FATCA, and for later iterations through the FATCA IGAs and continue through the Common Reporting Standard, you determine whether a legal entity is reportable by classifying them. If they've got a classification which is consistent with reportable status, then they are reportable. Equally, with the US Treasury version of FATCA, if they've got a Chapter 4 classification that's consistent with withholding, then you would withhold on them. But as we've discussed, and I know I've gone over it many, many times now, no withholding under an IGA unless you're doing it wrong, okay? And that's for the most part. We've discussed the notable exceptions, but they are notable exceptions. Also, I'd like you to bear in mind there's very little reporting that occurs for FATCA. And why do I say that? Well, you're reporting your NPFFIs, and I've explained why there'll be very few of those. And you're reporting recalcitrant account holders. You're reporting these populations in aggregate, by the way, and I think you split them out, those aggregates out into those categories where there are US indicia and where there aren't, okay? But you're not going to have, if you're doing this right, you're not going to have many NPFFIs and recalcitrant account holders. So you will be reporting specified US persons, but I wonder really how many specified US persons you've got for FATCA. I mean, I worked at one very prominent investment bank on a project much like this. They thought they had 14,000 reportable customers, and I got that number down to 22, not 20, without any outreach, by just applying common sense approaches to the regulations, publicly available information, so on, so forth. And I'll explain some of that. But in terms of FATCA, there's very little information to pass on. Specified US persons, controlling persons, where there are US beneficial owners or controlling persons, reporting in aggregate on NPFFIs, recalcitrant account holders, splitting those out into whether there's US indicia or not. In terms of volume, that's not a lot of reporting. Now, it may be an incredible administrative burden. It may be a pain in the proverbial. I'm not saying otherwise. But what I am saying is, in terms of volume, you're not talking about a large population, okay? Not for FATCA. For CRS, maybe, but just bear in mind, for CRS, you're never reporting FFIs, with one notable exception. That is when you're dealing with a customer who's in a non-participating CRS jurisdiction and is an investment entity. Don't worry, I'll explain that, but that is an exception. Is that there's no reporting for any form of active NFFE. And the only qualification I would make to that is that whilst the US Treasury version of FATCA, and I have harked back to that and I said I wouldn't, but whilst that does things like it identifies charities higher up in the process, so 501c, so they would be exempt beneficial owners before you even looked at them as being NFFEs. The same's not true under the CRS or under variations of the IGA. So you could have a charitable organisation or a non-profit organisation being an NFE and being active under FATCA, but not being active under the CRS or the IGA variants of FATCA. Those charities would have to go under the same tests as any other NFFE. That is, you'd have to look for controlling persons. So there's a difference there in terms of how did that client get to be an NFFE, and if they're a charitable organisation, we can't just assume that they're not reportable. Even if they're an active NFFE, we have to treat them as if they might be a passive NFFE and establish controlling persons. That's very nuanced, that's very much into the detail. What I'm trying to illustrate here is that there's, in terms of volume, very little reporting for FATCA, and also very little volume of reporting for CRS. Now that assumes you get the documentation right, and by documentation I mean the classifications right. And we'll go on to explain what happens if you get any of those things wrong. But if you do these things right in terms of volume, no withholding, and very little reporting. And just to reiterate, I'm not saying the reporting is not a burden. I'm not saying it isn't a pain in the proverbials. I'm sure it is. But in terms of volume, it's not massive. Really what I would say to you is that FATCA is all tax, colossal administration. The administration is all about getting the classification right. So let's have a look at this colossal administration and explore whether it really is colossal. What's the obligation then under classification or identification of payee, as it's known in the regulations? What does it consist of? Well, it consists of your pre-existing AML KYC regime, so all the things you had in place for KYC, AML, before FATCA, before CRS, notwithstanding anything that's in FATCA and CRS, it's your pre-existing AML KYC obligations without prejudice. In addition to the pre-existing AML KYC, that may vary by local law, you've got these key things. You've got to establish the FATCA status. So the FATCA status you've got in an appendix to the training materials provided to you with this video. So the FATCA status, and do bear this in mind actually. You've got something like, from memory, I think it was 41 for legal entities, for legal entity customers on that list. Actually, that might be for all of them, including natural persons. If you're using GINs, and some people are saying, oh, you should always use GINs, but we'll park that for just a moment. If you're using GINs, always bear in mind that the last 3 digits of any GIN are always the ISO 3166 code for that particular jurisdiction, which I know sounds terribly anorak. But for example, in the UK, FFIs that are in the UK will always have the digits 826 at the end. Cayman Islands will always have the digits 136 at the end. The US would always have the digits 840 at the end, and that's simply because the ISO 3166 code for the UK is 826, Cayman Islands 136, and the US 840. And so regardless of how you're doing it, if you've got a compliant FFI and you're trying to classify them, you should be looking at which jurisdiction they're in. You should be looking at their GIN code, their GIN number, and not simply classifying them as participating FFIs carte blanche, because there are distinctions to be made, and there are distinctions that are made in the reporting. Okay, so whether that be reporting via a 1042, 1042S, or 8966. So please make sure that you understand that that distinction has to be made. They are all, in all honesty, non-reporting statuses. So I don't personally believe that you'd be in material breach for having those things wrong. I do believe you would be if you wrongly classified them as a non-reporting status when they were actually reporting. But there's very little benefit in not making that distinction, and it's a distinction that can be automated. And also, in terms of the changes that are being made in jurisdictions, it's really useful to have this one right. And let me explain what I mean. Switzerland, they're moving from a Model 2 to a Model 1, okay? And we're going to talk in a moment about a change of circumstances. A change of circumstances definitely includes situations where you've got a change to the FATCA status, okay? So moving from a reporting Model 2 FFI status to a reporting Model 1 status is a change of circumstances, all things being equal. The regulations and the guidance dealt with this. I think it was around December of last year, January of this year, it being June 2017 when I'm recording this video. And they make it clear that if you're moving from a Model 2 reporting Model 2 status to a reporting Model 1 status, that's not a change of circumstances in the true context of a change of circumstances, even though it's actually a change in the FATCA classification. And so really what I'm trying to do here is I'm trying to illustrate the importance of making that distinction and getting it right, so that all of your Swiss clients who are at the moment reporting Model 2 FFIs, you can simply shift them from Model 2 FFIs to reporting Model 1 FFIs, because the whole jurisdiction has shifted. Okay, if you've got them all just jumbled up into a morass of reporting of participating FFIs without having made that distinction, you've got something of a mess there that there's really no benefit to having. You've saved no money, and it should be quite easy actually to make the distinction based on GINs and which jurisdiction that they're in. Okay, apologies if I explain that at too much length. So you've got to get 5 things from what's often referred to as colossal administration, if you refer to FATCA as FATCA tax colossal administration. And that's about getting the identification right. You've got to get the FATCA status right. And we mustn't assume that we're getting it right. I'm not saying we're getting it wrong, but let's just say let's not assume that we're always getting it right. There are nuances there. You've got to get the CRS status. And again, you've got the CRS statuses in the pack you were provided with with this training material. You've got to establish the tax residencies. Now, people often assume that you've only got tax residency in one country, but I've seen customers have tax residencies in up to 5 jurisdictions at the same time. There's no limit. I mean, they may have more than 5, but I've certainly seen that 5. And so you've got to establish all of the tax residencies that a customer has. And by the way, just because the FATCA are always looked at US citizenship, you can have US citizenship and still have tax residency in another jurisdiction. So just because you've got a W8, just because you've got a W9 for somebody which says that they're an American, doesn't mean that you've established all of their tax residencies. They may well be a US citizen for tax purposes and have tax residencies everywhere else. Okay, so it's important to understand that a customer can have multiple tax residencies. So FATCA status 1, CRS status 2, tax residencies. You've also got to have a tax identification number, a TIN, for every one of those tax residencies. But I should explain, there are exceptions. Not all jurisdictions issue TINs. So that's one exception. The OECD does list the jurisdictions and the TINs and the convention for those TIN numbers. So that's a useful source. There are other exceptions as well. Things like in Australia, they do issue TINs, but it's not legal to report those TINs. So this is actually quite nuanced. And in 5, you've got to establish the controlling persons if the FATCA status was that of a passive NFE, or the CRS status was that of a passive NFE, or this is under the CRS, if the CRS status is that of an FI that's actually an FI because it's an investment entity, and that investment entity is in a jurisdiction that doesn't comply with the CRS, is not complying with the CRS. And again, you've got that in your training materials. So just to recoup, there's 5 things you need. And if you get it right, you've got a fairly simple FATCA CRS DAC 2 program. FATCA status, CRS status, tax residencies, TINs of all of those tax residencies, but navigate the complexities and the nuances there about whether there are TINs in those jurisdictions and whether those TINs can actually be reported. 5, the controlling persons of non-financial entities, and that includes, the controlling persons of passive non-financial entities, and that includes for FATCA, non-financial entities, that includes for FATCA, passive non-financial foreign entities, for CRS, passive non-financial entities, and for CRS, investment entities who are investment entities in jurisdictions that are not participating with the CRS. That's it. Those are the 5 key things. The rest is just pre-existing AML KYC, and again that may vary by the local laws in a particular jurisdiction, but you've got the AML KYC as per the law in that local jurisdiction, plus these 5 data fields. Onboarding new to bank customers in the context of FATCA DAC 2 CRS. You must establish these 5 core data elements that we talked about earlier inside of 90 days. So ideally you would do it at day 0, but you have to get it done inside of 90 days. If you don't get it done inside of 90 days, that is a material breach. Pre-existing customers. Well, for FATCA, you'll have done all of that work by the 1st of July 2016, otherwise you would be in breach. So for FATCA, you would have already established their FATCA status, the controlling persons et al. You'll have done that by the 1st of July 2016. For the common reporting standard, bear in mind there are 2 tracks at the moment. You've got your early adopters and you've got the ones that start a year after that, often referred to sometimes as late adopters and sometimes referred to as other than early adopters, or otherwise referred to as fast followers. I'm going to refer to them as fast followers. So for CRS early adopters, all of your high value accounts, you'd have captured the 5 fields by the 31st of December 2016. For all of the other accounts for early adopters, you'll have done the same thing by the 31st of December 2017. And for fast following jurisdictions, it's the same thing, but exactly 1 year later. There are no de minimis rules under the CRS. There's an exception. There always is for everything to do with FATCA, CRS and DAC 2. But whilst FATCA had de minimis thresholds and the IGA versions of FATCA had de minimis thresholds, the CRS doesn't, with one exception. And so because of that, there's no point applying de minimis thresholds, because you've got to apply them because they don't apply to CRS, with this one exception. And that is pre-existing legal entities with a value of less than $250,000 US. Okay, so if you've got a legal entity and when you've reviewed it previously and when you continue to review it at 31st December, it continues to have a balance of less than 250,000 UK, 250,000 US, and you're applying that de minimis threshold, then then in those cases the de minimis rule can exist. The de minimis threshold can exist, but there is no other de minimis threshold under the CRS, so there's no point applying it for FATCA. Okay, so we've established there are 5 key data elements to FATCA and CRS compliance. How do we go about achieving that? Well, we can use publicly available information. Now let me explain before I do that. If there are US indicia for a particular client, you cannot use publicly available information to classify them. You're going to have to get, I'm afraid, a self-certification. There's no avoiding that. So just to reiterate, if you've got US indicia, you're going to have to get a self-certification. Okay. Excluding cases where you've got US indicia, you can do the following things to achieve to fulfill the criteria of populating the 5 key data elements. You can use publicly available information. This would include things like GINs, which are available on the IRS database. If they've got a GIN, then you're going to know that they're an FFI. You can use the logic of the last 3 digits to determine whether they're Model 1, reporting Model 2, participating FFI, even whether they're a sponsored FFI. You can do all sorts of things. It's worth pointing out that there are also direct reporting NFFEs in that list. I'm not sure how many there are, but in any event, we're not talking about reportable statuses here. So there's a lot you can do actually with the GINs, and if there's an appetite for talking about it, then please let me know. I'll stop the video and we'll talk about it. Okay, you can use things like standard industry codes. So in the US, they're NAICS codes. Not that you'd apply this to the US because you can't use this where there's US indicia. In the UK, you apply SIC codes, standard industry codes, and I believe in the Netherlands, you have got the Dutch Chamber of Commerce SBI codes. That's absolutely legitimate. You can use them. You can also use, for things like establishing tax residencies, the place of incorporation. It's a proxy, of course it is, but you can use that kind of thing, place of incorporation. And for individuals, you can apply the residence address test. Again, and that's a proxy for their tax residency. I need to explain that where the account's a high value account, i.e. 1 million or more, for that individual, you can't apply the residence address test as a proxy. The thing to take away from this is that you don't always have to get a self-certification, and you can use publicly available information unless you've got US indicia, and you can't apply things like the residence address test if you've got a high value account for an individual. Okay, but there's a lot you can do with publicly available information that involves no customer outreach. Change in circumstance. Now, the regulations and guidance talk about a change in circumstance in this context. They used the example for FATCA of a customer who previously had no US indicia, taking on some US indicia, therefore they become reportable. Naturally, that's a change in circumstance, and then you would solicit for a self-certification. Beyond that, there's no prescription as such about what a change of circumstance is. So certainly taking on US indicia, where previously there was none for a customer, that's a trigger for of a change of circumstance and a W8 and a self-certification. Beyond that, when we set triggers, we're interpreting what we mean by a change of circumstance and what a trigger should be. And it's worth bearing in mind that a change in the FATCA status, although that's a change in Chapter 4 status, isn't always a trigger for a change of circumstances. The regulations make it clear, and they were changed December last year, January this year. What's changed so much as explained that, for example, Switzerland, which moves from a reporting Model 2 FFI status, moves from a Model 2 IGA to a reporting to a Model 1 IGA, and therefore its FFIs move from reporting Model 2 FFIs to reporting Model 1 FFIs. That's not a change of circumstances in this context. Okay, so you wouldn't have to go out and get a W8 or a self-certification from a Swiss FFI simply because Switzerland itself had moved from a Model 2 IGA to a Model 1 IGA. What matters is a change of circumstance which transitions a customer from a non-reporting status to a reporting status. That really matters. Also, bear this in mind: if a customer moves and they've got a new address in the same jurisdiction or a new telephone number in the same jurisdiction, that's not in and of itself a change of circumstance. It is possible to have more than one status for FATCA, and let me explain the precise example why I say this. And this is the second time I'm going to break my rule of no longer referring to the US version of Chapter 4, but I'm going to refer back to the US Tax Code Chapter 4, and so we're applying this here to the US and branches of US withholding agents. Now, they can only treat a financial institution as complying with FATCA in the context of having an IGA, if they've got a GIN which the customer has given them. So let's just say, let's pick an example everyone knows, BlackRock, okay, or Deutsche Bank. In an IGA jurisdiction, when you're dealing with BlackRock, a Deutsche Bank, you would know that you were, and you would classify them as reporting Model 1 FIs, even without a GIN. I've yet to see a requirement in a local financial instrument which says that you must get a GIN and verify it. I have seen local guidance which says that you can use a GIN to verify that they're an FI, but I haven't seen an explicit requirement in an IGA country, in a local instrument of that local jurisdiction, which says you must get a GIN and you must verify the GIN. But in the US it's different. They have to apply the US Treasury version of FATCA, as do branches of US withholding agents. And so in the context of BlackRock and in the context of Deutsche Bank, they would need to be furnished by the client with a GIN, and they would then need to go and verify it. And only after they'd gotten this GIN from the client and they'd verified it, could they classify the FI as a Model 1 reporting FFI. Now this is important because without that, the US and that branch of the US withholding agent have to classify them as NP FFIs, and that's because they're applying a very different version of FATCA. They're not applying the IJ version of FATCA, they're applying the US Treasury version of FATCA. So they would have no choice without the GIN that's been verified to treat that customer as an NP FFI, and that would be a legal requirement. To do otherwise would be a material breach. And at the same time, in IGA countries, you wouldn't do that because they can't be an FFI and an NP FFI, as we've discussed at length, without going through the significant non-compliance routes. They're very, very different. So thus, you could have two FATCA statuses, both equally legitimate and required by law, coexisting. They're not mutually exclusive, they can coexist. And in that scenario, they would, as a matter of necessity, coexist. So you can have more than one status. FATCA reviews. There is no FATCA review under the IGA versions of FATCA. You would simply review the 5 key data fields we talked about before when you're reviewing in the normal course of transactions under your pre-existing AML KYC under local law. And also because there's no de minimis rules under the CRS apart from legal entities. So yes, I guess the exception would be that if you've got legal entities and that you've applied the de minimis rules for, then you would have to review at the end of the year that they still had a balance of less than 250,000 US. So you could have a FATCA review there. But unless you've got those types of pre-existing legal entity customers and you've applied the de minimis rules for less than 250k US, I don't know why you would have a FATCA or CRS review per se. You should, all things being equal, just have a AML KYC review in line with your pre-existing local law. And naturally, if you come across, as part of your AML KYC, indications that there might be a change of circumstance, then that would trigger dealing with these 5 fields. But without that, there is no such thing as a FATCA CRS review required by the regulations, and by the regulations I mean the local instruments that implement the FATCA IGAs for those local jurisdictions. Also, the self-certifications, the W9s and W8s, they're evergreen, and that's true for FATCA Chapter 4, this is the 3rd time I've broken my rule, and for Chapter 3. And there are exceptions to this. So the exception is where there's a change of circumstance. So we've talked about that at length. So a change of circumstance would trigger a new self-certification, it would make the old one invalid. From memory, I think it's after 90 days of the change of circumstances being triggered, so 90 days. The customer, by the way, when they fill out a W8 or a W9, makes a commitment, which they sign towards the end of the form, that they'll tell you if there's a change of circumstances within 30 days. Nonetheless, They may or they may not. If the bank becomes aware of change of circumstances, the pre-existing self-cert's only valid for 90 days. Okay. Another way that they can become invalid is where a new self-certification has been provided by the customer. And an example of where that may happen is where an application for treaty relief has been made on a W8 BENE. Applications for treaty relief are nothing to do with FATCA per se, they're to do with Chapter 3. And whilst W8s are evergreen for Chapter 3 and Chapter 4, applications for treaty relief are not evergreen. They expire the December 31st after the form was signed. So conceivably, if someone needs to refresh their application for treaty relief, they're going to send you a new self-certification, and that renders the old one invalid. With those two exceptions, the change of circumstances and a revised self-certification, a self-certification is evergreen. So indefinitely valid indefinitely. The ongoing validation of these 5 key data elements is simply part of your pre-existing AML KYC. Said differently, when you're reviewing your AML KYC as a matter of course, you would also look at the FATCA status, CRS status, TINs, tax residencies and CPs, which isn't to say that you'd go out and you'd re-verify. You'd look for reasons to find out why these 5 data elements may have changed. And if you've got indications that they may have changed, then you'd go and revise them. But this isn't the same thing as saying that you treat them as invalid every time you do a AML KYC refresh. That's not the case. Every time you do an AML KYC refresh, you'd look at these 5 key data elements, and if there's an indication that they have changed or they may have changed, then you would get it. Then you would solicit for a revision of these 5 key data elements under FATCA and CRS. It's all part of AML KYC CDD. Host country tax authorities have indicated that they'll take a risk-based approach to auditing FIs and making inquiries. They after all have limited resources. They can't audit everybody all at the same time, and they'll be looking for things like a disproportionately high number of NPFFI numbers for FATCA, recalcitrant account holders for FATCA, undocumented accounts for CRS. And bear this in mind, if you're in an IGA country, volumes of NPFFIs, I'm not going to use the phrase red flag, but it would indicate that there's a question to be answered. So what happens if we don't deal with these 5 key data elements correctly? Well, we'd start to classify NPFFIs, we'd start to classify FFIs as NPFFIs incorrectly. That will lead to withholding, even in an IJ jurisdiction. Now, as I've explained, hopefully at length, and hopefully in a way that can be understood, you can't have an NPFFI in an IJ country unless they've gone through significant non-compliance. But that isn't the same thing as saying that an FI can't by accident classify an FFI as an NPFFI, well, either by accident or by just not knowing what the regulations actually say and not knowing about the IJ variance. So bear that in mind. If you're wrongly classifying a customer, that's going to have consequences. It's going to lead to withholding potentially where there shouldn't be any. It's going to lead to reporting the customer where potentially they shouldn't be reported. Now just think about the reputational damage that could do. Also, bear this in mind. If you wrongly classify a customer and give them a status which would mean that they're going to be withheld upon under Chapter 4, that's the 4th time I've violated that thing I said I wouldn't do, then that customer's going to have a problem because you've withheld on them for Chapter 4, but there was no withholding for Chapter 4, and maybe they should have been withheld upon for Chapter 3. The process that customer's going to have to go through to get a refund for the IRS, if you've applied withholding under the wrong regulation, that's painful. So that's a really bad customer experience. Probably isn't great for reputation. So you'd have a really poor customer experience. The volume of NPFFIs that you were reporting could well trigger inquiries or an audit where there otherwise wouldn't be an audit. That's really not the happy path. This brings to a conclusion this second section of the training on FATCA, CRS and DAC2. And the key thing I'd like you to take away from that is there are 5 data elements which you really must collect to comply with FATCA, DAC2, CRS. And these are the 5 data elements which are on top of pre-existing AML, KYC measures that are already part of local law without prejudice to FATCA, and without prejudice to DAC2, and without prejudice to CRS. They were pre-existed anyway for AML, KYC. So in addition to pre-existing AML, KYC, you've got to capture 5 key data elements to comply with FATCA and CRS. You've got to get the FATCA status, which we've talked about at length. You've got to get the CRS status, tax residencies, all of the tax residencies, don't assume there's only one. Okay? And you've got to get the TINs for all of those tax residencies, or establish a reason why you can't get a TIN for that particular tax residency. And 5, you've got to establish the controlling persons of passive NFFEs. And just bear in mind that in terms of passive NFFEs, what I mean by that is in the context of FATCA, passive NFFEs, in the context of CRS, passive non-financial entities, and additionally under CRS I mean investment entities. Those are FIs that are investment entities that are in tax jurisdictions, and those tax jurisdictions that they're in are not participating with the CRS. So it's really those 5 key things: FATCA status, CRS status, tax residencies, TINs, controlling persons. That's it.